Gilbert on behalf of Jeremy Smith and 25 CF 1505. We're here for a change of plea. At this time, I'd like to withdraw the plea of not guilty, change it to a plea of no contest to count 2 in exchange for terms. I have a signed plea agreement and score sheet. May I approach?
Granted. You may proceed.
So, all right, this time he pleads no contest to count 2, which is using a computer to facilitate or solicit sexual conduct of a child. The sentence agreed to between defendant and state of 21 months in DOC, followed by 3 years sex offender probation, sex offender designation, 100 hours community service work that can be bought out by making a donation to a nonprofit organization. No internet cable devices, must notify each employer of his probation or sex offender status, no contact with minor children, no access to places where children congregate, sex offender evaluation to be completed within the first 60 days of probation and comply with any recommended treatment, surrender all property such as electronic devices that were seized by law enforcement in this case.
Is that the state's agreement?
I'm sorry.
Is that the state's agreement?
Yeah, it is, Your Honor.
All right. Raise your right hand, Mr. Smith. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Gilbert said and you signed the written plea form?
Yes, sir.
How old are you?
42.
How much education do you have?
High school diploma.
You able to read and understand the plea form? Are you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what Mr. Gilbert just announced to me?
Yes, sir.
Do you understand by this plea arrangement that you're pleading no contest to the announced charge?
Yes, sir.
And that tells me you believe the state has the evidence necessary to prove your guilt to the jury and you're not going to contest that.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to present that evidence to the jury and convince the jury beyond a reasonable doubt of your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty. Count 1 will be dismissed and you'll be sentenced to 21 months in the Department of Corrections, followed by 3 years of sex offender probation with the designation, the community service hours, no internet capable devices, and the notification requirements, no contact with minors, no places where minors congregate, your evaluation, and all property that was seized must be forfeited. Is that what you understood?
Yes, sir.
Do you understand this designation will affect where you can live, where you can work, who you can be around?
Yes, sir.
It also requires regular reporting and changes in multiple different sets of circumstances for you personally
Yes, sir.
that you must comply with. Any violation of that would be a violation of your probation and also a separate criminal charge. Do you understand?
Yes, sir.
Mr. Gilbert answered all your questions about the plea and how it affects you.
Yes, sir.
Are you satisfied with how Mr. Gilbert's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea with the adjudication. Thank you. Good day. Step over this way, please.
That's all I have, Your Honor. Thank you.
Thank you, Mr. Gilbert. Good day. Ms. Merrifield.
Good morning, Your Honor.
Good morning.
Morning, Your Honor. Brandy Merrifield on behalf of Cortez Landrum. It's 25 CF 2342. And Judge, we have reached a pretrial intervention agreement, if I may approach.
Granted.
And I have provided a copy of that pretrial intervention agreement to probation. Mr. Landrum resides out of state, so he would go directly to the probation office and check in with them today to get started and be instructed on those terms and conditions.
Thank you very much.
All right, that's it. And Judge, the last case I have on the docket is Curtis Tatum in 25 CF 1040. If Mr. Snell and I may approach.
Yes, ma'am.
And Judge, that should be all I have on the docket this morning.
Madam Clerk, is that all for Ms. Merrifield?
Thank you,
All right.
Judge.
Thank you. Mr. Shaw.
Morning, Judge.
Good morning, Mr. Shaw.
The only case I have on the docket this morning is Geraldine Joe Swanson. That's 24 CF 2748. Your Honor, we have a written plea agreement and the score sheet. Would you like me to announce, or do you want me to respond?
Yes, sir. Go ahead and announce the terms and conditions.
Judge, at this time, Ms. Swanson will withdraw her previously entered plea of not guilty, tender a plea of no contest as charged. Adjudication will be withheld, 36 months probation on count 1. There'd be 12 months probation on counts 2, 3, and 4. There would be early termination at 24 months, provided no violations and all conditions are met. There'll be a substance abuse evaluation and any treatment recommended, anger management with the counselor of the defendant's choice, 1 session of the victim impact panel, no alcohol or drugs without a prescription, random UAs comply with injunction in case number 24 DR 3516, restitution of $2,500 to Jody Gray, Jodigray, within 60 days. Fines and court costs, I believe, are $867. Cost of supervision is $40 a month. Judge, may I approach?
Is that the state's agreement?
It is, Your Honor.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay, and you can put your hand down. You heard what Mr. Shaw said, and you signed the written plea form?
Yes, sir.
How old are you?
32, about to be 32.
How much education do you have?
A little bit of college.
You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And is what you read what Mr. Shaw just announced to me?
Yes, sir.
Do you understand by this plea agreement that you're pleading no contest to the announced charges?
Yes, sir.
And that tells me you believe the state can prove your guilt to the jury and you're not going to contest that?
Yes, sir.
Do you understand by doing this you're waiving your right to that trial by jury?
Yes, sir.
In this case, adjudication will be withheld. You'll be on the 36 months of probation with determination at 24 if no violation. You've got your evaluation and treatment if recommended, your anger management with your counselor, the impact panel, and no substances without prescriptions and testing to confirm that, and the restitution that was announced. And that's a straight full payment, Mr. Shaw, within the 60 days?
Yeah.
Okay. I just want to be sure probation is on board with that, because if that's not done, then that would be a violation if it's not paid within the 60 days. I just want you to be sure you understand that.
Yes, sir.
So if there's some issue with that, you need to be in touch with Mr. Shaw immediately, okay? And then cost of supervision. Is that what you understood?
Yes, sir.
All right. Has Mr. Shaw answered all your questions about the plea and how it affects you?
Yes, sir.
Are you satisfied with how Mr. Shaw's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you. Thank you, Mr. Shaw. Anything else for you today?
No, Your Honor. Thank you, Judge.
Thank you. Good day. Mr. Patel.
Good morning, Judge.
Good morning, Mr. Patel.
Jay Patel on behalf of Andrew William Thomas.
Oh, and that just reminds me of something, Mr. Patel, now that you're here. There's a bar meeting tonight, y'all, that are members of the bar, and you should probably be there at Jake and Henry's, just saying. Right, Mr. Patel?
I very much appreciate the announcement, Judge.
Starts at 5:30.
I will be there.
Celebrating all the past presidents of the local bar association,
That's exactly right.
95 and 96. Before some of you were born, no doubt.
We're going to talk about that because there's a whole lot of history that I need to get from the 90s presidents.
Go ahead, Mr. Patel.
Judge, can we approach?
Granted. All right. Anyone else for you, Mr. Patel?
Nothing further, Judge. May I be excused?
Anything else from Mr. Patel, Madam Clerk? Okay, thank you very much. Yes, sir, good day. Ms. Dudley?
Good morning, Your Honor.
Good morning.
I have Derek Steele in 2012 CF 1876. Okay.
Now, approach, Your Honor.
Yes. Okay. And Ms. Dudley, you agree to that?
Yes, sir, he has a new case in Crestview. Your Honor, this is Mr. Steele. I have explained to him that we're going to his VIP will be transferred to Crestview to track with his new law case on that docket. We've already heard the plea of not guilty on the violation. Or denial, sorry.
All right, I've signed the order. And Madam Clerk, we'll set that on the next available docket up there, is that right? Okay. Do we know that date, or it's 12 CF 1876?
The new case number. Do you know the new case number?
I think it's in the motion.
26 CF 451. And I believe it's set for 6/22, I believe.
Pre-trial set for June 22nd, correct?
All right, set this to run concurrent. Thank you, Ms. Dudley.
Yes, sir.
Thank you, Ms. Steele.
Yeah, that's all I have.
Madam Clerk, anything else from Ms. Dudley?
No.
Okay, thank you, Ms. Dudley.
Thank you.
Ms. Jaquith.
Good morning, Your Honor.
Good morning.
I have only one matter on this morning's docket. That's Mr. Edrin Sanders, and I was just appointed to his cases at the end of last week. Your Honor, in this
And
matter,
is that,
and those case numbers, Your Honor, are 23 CF 1862 and 24 CF 348. Your Honor, my only concern with these cases, I think we can get these cases worked out. However, my concern is making sure that the misdemeanor case that triggered this VOP is also, we've also got a plan of action for that. So I would just ask that we continue these to next week, the 23rd or 24th, and I apologize, I'm not sure which date it is. But I would ask that we just continue it 1 week. I think we can probably get these worked out and get Mr. Sanders out of custody as soon as I have an opportunity to reach out to the alleged victim in the misdemeanor case.
all right, so 4/24?
Yeah, and I'm sorry, if is that the right date, Madam Clerk?
23rd, sorry,
Okay.
4/23.
At 9 a.m., yes, sir. Thank you
Right.
so much.
Change of plea?
I expect it to be a change of plea. I have a preliminary idea of what the state is willing to agree to. We just need a little bit more time.
All right, very good.
Are we continuing the arraignment or denying?
Are you denying?
We'll deny for now, Your Honor, and then resolve next week. Yep. Your Honor, that is all I have. I don't believe any of the, Mr. Gomez had asked if I could address a couple of my afternoon inmates, but I don't think they're here yet, so.
They're not up here yet.
Okay, I can hang around. If you don't mind, at least Phillips and McNamara, so that Mr. Gomez doesn't have to remain for those. And I'll, if it's okay with the court, I'll wait.
No, that was.
Your Honor, I will wait until they get those up here so that we can resolve as many as possible.
He's seen. That's the one I really want to know, so I can release the probation officer. Mark, can you put me in the lead?
All right, Mr. Cotton?
Your Honor.
Yes, sir.
How are you today, Judge?
I'm good. How are you, sir?
I'm doing well. Your Honor, I'm here today, for the record, Byron Cotton with Robert Rosario. That's case number 25 CF 1068. Your Honor, we've reached an agreement on that case. I've reached out to probation, and we have confirmed one of the, this will have a sex offender sanction and designation, and so he's going to have to move where he lives. We have provided that address to probation, and they have given me, I'm going to use the words tentative approval. They don't finally approve, is my understanding, until there's a judgment entered. So I think we're ready to move forward. The family's made arrangements to move. So I think Ms. Leone and I, we're ready to plea at the first available docket, but she indicated she might have a conflict on our next court date. I'm not sure.
I would be fine to set it for next week, one way or another, Your Honor. So it's fine.
I believe the clerk gave me
423?
Yes, sir, if that will work for the court.
Yes, sir.
Okay, Your Honor, that's all I believe I have. Madam Clerk, do you see me on the docket for anything else? All right. Thank you, Your Honor. That's all I have for the
Thank you.
court.
Good day.
Yes, sir, you as well.
All right, Mr. Powell, do you have something with us? And other Mr. Powell, you have something as well? I didn't see you on the list. Okay, we'll get to you next. Good morning.
Hey, Judge, good morning, good morning. We had,
And what case do we have today, Mr.
Kenneth
Powell?
Martin, Judge, 26 CF 554F. It's a motion for bond reduction.
All right. Go ahead, please.
Judge, Mr. Martin has never been in trouble in his whole life. He has no blemish whatsoever. He was in Special Forces. He's retired. The bond of $200,000 is absolutely prohibited from me meeting with him. I can't meet with him in the jail. He's charged with 20 counts of possessing obscene material. He's a retired Special Forces, and he's a very close friend of Mr. Clyde Williamson, who I'd like to speak to the court, and I'd like to do it at the bench. That would be
All right. Well, please approach. All right, sir, and we'll expect your written order, and he cannot be released until the written order is processed.
Thank you, Judge. I'll go prepared now.
All right, thank you.
Thank you, Judge.
Thank you, sir. Good day.
See you, Judge.
Good day. Is that all for you, Mr. Powell? All right, good day. Now, Mr. Powell. The other Mr. Powell. Dixie Powell. What do you have today, Mr. Powell?
Yes, sir, Your Honor. We have State versus Zarain Wayne, case number 2026-962.
962.
State has filed a no action on that case, no pros.
Oh, yeah, I think it's already off the docket, right, Madam Clerk?
I still have it.
Okay, I'm showing it as 26144, Mr. Powell.
Yes, 144A, I apologize, Your Honor.
Okay, all right.
That was the agency number I called out, sorry.
That's all right. All right.
And then, that was the one where we had the return of the property, but I think that'll take care of it.
All right, so the case is no pros, correct?
Yes, sir.
All right, thank you very much. Anything else for you, Mr. Powell?
Yes, Your Honor, I have Zumi Zal, case number 2026 CF 130.
130?
Yes, sir.
All right.
And in that case, Your Honor, we talked to Mr. Snell the other evening about this case, and he filed the information, and we had filed a motion for release for ROR due to the fact that the information wasn't filed within the 63 days under the rule. I would just ask the court to read the motion. Let's take that under advisement. I think we're going to be able to work something out on the case, if that's okay. Both of these ladies have moved back to New York with their husbands, and they're under pretrial services. So that was the reason for the motion, so they could not have to report in once a week for pretrial. And I'm getting calls from both husbands about 3 or 4 times a day wanting to know what's going on in Florida.
All right, so you're not asking for disposition today because you believe you'll have a voluntary disposition of the case?
Yeah, I think Mr. Dre and Mr. Snell will be able to work something out on that case.
All right.
Yeah.
Is that okay?
Granted. Y'all too. Bye-bye. Correct.
Your Honor, I have Matthew Phillips. He's on the 2 p.m. docket. That case number is 25 CF 1079. We have reached an agreement with the state. Mr. Phillips and I discussed this. However, I do need a pause to allow him to sign. As to Mr. Phillips' case, we have reached an agreement. He'll be pleading no contest as charged. The agreement is an adjudication of guilt. He is already a convicted felon. 2 years of probation. There is a $40 per month cost of supervision. However, I'm going to ask the court to waive that for the first year so that he can get out of jail and get back to working and get his funds together. $967 in court costs. There's a $150 cost of defense. There is $500 in restitution to Tobias Sprague. No contact with Tobias Sprague. No trespassing at 233 Burnett Avenue Northwest in Fort Walton Beach, Florida. And he'll need to enter and successfully complete an anger management course. We have no objections to the score sheet as drafted. May I approach?
Granted.
Thank you, Your Honor.
Yes. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. You heard what Ms. Jaquith said, and you signed the written plea form.
Yes, sir.
How old are you?
I'm 35.
How much school do you have?
Over high school.
Okay. All right. You able to read and understand the plea form?
Very well.
Did you do that before you signed it?
Oh, yes, sir.
And is what you read in the plea form what Ms. Jaquith just announced?
Yes, sir.
Do you understand by this plea that you're pleading no contest to the announced charges?
Fully.
And that tells me you believe the state could prove your guilt and you're not going to contest that?
Yes, sir.
In this case, you'll be adjudicated. And do you understand by making this plea, you're waiving your right to that trial by jury?
Yes, sir.
You'll be adjudicated guilty beyond 2 years of probation with the standard conditions, plus the restitution, no contact, and no trespassing at the announced place. And you must complete the anger management course.
Yes, sir.
Ms. Jaquith answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with how she's represented you?
Fully.
The court will find the plea to be freely and voluntarily entered into and accept the plea with the adjudication. If you'd step over this way, please.
Take this with you. Take that with you. You need to go to probation as soon as you get released. Okay? Your Honor, the next on the docket is Barbara McNamara. Ms. McNamara is present in 25 CF 626. Your Honor, given that we are discussing Ms. McNamara's protected health information, can Mr. Gomez and I approach briefly?
Granted. All right, we'll set this for status on 4/23 at 9
Thank you, Your
o'clock.
Honor.
All right, thank you. Yes, ma'am, good day.
And Your Honor, I have one other matter on the 2 o'clock docket, but I'm willing to address it. We don't have anybody here for it. Me and Miss Leone have that case. Tammy Moore, 23 CF 1607. If the court would allow me to just go ahead and do that continuance. Given the short turnaround of the continuance, I didn't have time to get it done in writing and have it docketed, so.
Okay.
But Your Honor, the state disclosed a new witness, and I need opportunity to figure out what this witness has to say, whether or not their testimony is even relevant to the limited issue of competency and things of that nature, and potentially list some counter witnesses as well. Obviously, I can't do that in just a manner of a couple days, which the state understands, and that's why they agreed to everything. And so at this time, I'm going to move to continue this. However, I'm out of the office on the 15th of May, and my afternoon of the 24th of May is also booked already, so I'm going to have to ask to move it to whatever the first date in June would be.
Any objection to that?
No, Your Honor, no.
All right, what date is that?
June 11th.
6/11.
Thank you. And Your Honor, if we can go ahead and
2
sit at 2
o'clock,
p.m., yes.
correct?
Thank you.
All right, very good.
And I believe that resolves all of my concerns for this afternoon, so I will not return unless I get paged to do so.
All right.
Thank you, Your Honor. May I be excused?
Yes, ma'am, good day.
Thank you. Have a good day.
Good morning, Mr. Nopes.
Good morning, Judge. I've got 2 cases. First case is Holly Martin.
And what's that case number, Mr. Nopes?
I'm sorry, Judge, 25 CF 1019 and 25 CF 1029.
All right.
Judge, I will tell you that she had an appointment, I think, to see me the other day, and she did not appear for that appointment. And we've emailed her a number of different times. We did speak to her on March 18th, and it was actually, the appointment was April 14th. So she, I guess, I don't know what's going on with her, but she's kind of becoming difficult to keep track of.
All right. State?
Say request a capias, Your Honor.
All right, issue a capias.
And then the next case I have is Susan Jane McFarland. And is she present?
Yes.
Okay. So, Judge, I'm going to be filing a motion of withdrawal. The last time we were in court on March 9th, she indicated that she had information, names, documents, etc. I gave her, I think I gave her my business card, and said, well, you need to call, set an appointment, and come talk to me about it, and bring me the information, and let's get it to the state and go from there. I've not heard from her since the date of the last time we were in court, which was March 9th. So I'm filing a motion to withdraw.
All right. Do you understand what he's saying?
Yes, I understand.
Okay. And were you appointed, Mr. Nopes, or retained?
I was appointed, Judge.
All right. Part of the conditions of your pretrial release is that you participate in moving the case forward. And Just reading the progress docket here, this case has been pending and kind of drifting for a while, right? And so how am I supposed to keep the case moving forward if you don't meaningfully participate in the case?
Sir, I'm losing my eyesight, and I have a hard time getting a ride somewhere. And I've had implants put in my eyes to keep the inflammation down. Right now, you're very blurry to me, all right? So I have a hard time seeing or doing anything. And for me to drive to Crestview, and I had told Mr. Noakes that I can't drive because my eyesight's going. My health has been bad. I've been through tests for the last 2 years. But I apologize.
All right, so, you know, you see Mr. Nopes on Zoom, you could make arrangements to do something else, but, you know, the case has been pending for a long time, and so you've got to participate meaningfully to move the case forward. So,
Yes, sir.
Mr. Nopes, you still wish to withdraw?
Yes, sir.
All right, and so, who's next on the list, Madam Clerk?
Jason Cobb.
All right, Mr. Cobb's appointed to represent you. Now, if you don't take care of business, then, and don't participate meaningfully, then I may revoke your pretrial release so that the lawyer know where you are and may have contact with you to move the case forward.
Yes,
All right?
sir.
And next court date would be when, Madam Clerk?
May 11th.
All right, so your next court date is pretrial conference on May 11th, all right?
May 11th, yes,
Yes,
sir.
good
And-
day. Mr. Nopes will provide an order of withdrawal and appointment of Mr. Cobb.
Absolutely. Thank you, Judge.
All right. Anything else for you to, oh, no, I guess not. All right. PD?
Judge, may I call Michael White? Mr. White is present and approaching in 25 CF 1696. We were set today as a status. And I believe the state may have an announcement.
Yes, Your Honor. The state is going to announce a dismissal in the case. It's time. We have lack of cooperation with the alleged victim in the case.
All right, case is no prost.
Good day. Sir. Have a good day. Judge, I'll pass it over.
Mr. Cochran.
We had a couple in the courtroom to address, Your Honor.
Yes, sir.
Starting with Mr. Stephen Mosley.
What's that case number, Mr. Cochran?
Yes, Your Honor, that case number is 25 CF 0261.
All right, yes, sir.
Yes, Your Honor, Mr. Mosley's violation, the big part of it is restitution. We've been here a couple times with issues about money. He is supposed to be getting his Social Security back. I've spoken to the state, they've agreed to us putting it out until June, so we'll know by then if he'll have his.
611?
That's fine. And we
No
can set
subs?
We can set it with subs, that way if it's not, if we can get it moving if nothing's happened. Is that what you're saying? Yes.
2 o'clock then.
June 11, 2 o'clock.
June 11, 2
June
o'clock.
11, 2 o'clock. All right.
Thank you, Mr. Mosley. Good day.
And then, Your Honor, we have Ms. Candace Murphy as a status, case number 24 CF 1592. This is a PTI status.
Right, actually, it's on for today, but I also show that it's on for 5/11, right, Madam Clerk?
Yes, Your Honor, we put it on today as a status. I have confirmed with probation, they have all the paperwork, we just gotta get Ms. Murphy on the phone with them to get instructed. All that paperwork just got done yesterday. We finally got everything settled. So by May 11th, this should fall off the docket with her being instructed before that.
Okay, so we'll leave it on for 5/11 for status.
Yes, Your Honor.
Okay.
That's all I have in the courtroom. The rest of mine are inmates.
Judge, I'll be right back. I'm going to grab Ms. Yesty.
All right, well, we got a few folks here today without attorneys, and as I think I've got, so as I call your name out, I'd ask you to come down. Now, everybody's entitled to an attorney, and if you can't afford an attorney, the Constitution of the United States and the state of Florida require that the state provide you an attorney at the state's expense. To do that, you're required to complete an application for that appointment. And it is a goofy government form. And if I hadn't been doing this for a couple of decades, I wouldn't understand how to fill it out. So I like people to fill them out here in the courtroom, then I look over them and look at the common errors, not because, well, yeah, because you can't fill the form out because it's goofy. I'm just telling, be honest with you. And that way, I look at those common errors and we fix them here in the courtroom. Because if there's even one single mistake or one box not completed, Madam Clerk will reject your form. I'd like to look at her and say just because she's mean, but no, it's because the statute requires her to reject the form even if there's one mistake. So I like to review those common areas where mistakes are made, so we only do this once instead of doing it over, if that makes sense. That way your case moves forward, and instead of wasting another court session just to have you fix the form, we try to get it done first. You can also have the right to listen to what the state has to say, and if you believe that you can accept their agreement to dispose of the case without the help of a lawyer, you can do that as well. All right, so I've got Casey Leach. Casey Leach. All right, you're here today without an attorney. Do you want an attorney to help you, or would you like to hear what the state has to say first?
I'd like to hear what the state has to say.
All right. The state have a voluntary disposition of the case.
Yes, Your Honor. As of right now, the offer would be adjudication of guilt, or admit the violation, I'm sorry. Adjudication of guilt, 30 days in the Okaloosa County Jail, and terminate all supervision.
All right. You've heard the offer. Would you like to accept that, or do you want an attorney to assist you?
I'd like an attorney to assist me because I just started a new job. I know I'm violated for
Well, don't talk about the facts of the case, right? I'll give you the form. You complete it, hand it back to the bailiff. Don't leave until you turn your form in and you get a new court date, okay?
Yes, sir.
All right. Cora Pickett. All right, you're here today without an attorney. Would you like an attorney, or would you like to hear what the state has to say first?
I'd like to hear what the state has to say.
All right, what does the state have an offer?
Your Honor, this is mainly a violation in regards to restitution. Do you have any ability to pay the restitution? Because that's going to affect my offer.
Actually, I've paid everything but $844, and if the court allows me, I'm employed full-time. I'm a property manager. I have Airbnbs that I manage. I have,
Ms. Ferris, can you verify that the outstanding amount owed is $841?
I see a payment that was made for $990 on the 13th of this month, but her outstanding balance was $2233.55. So
And that includes like court costs and everything?
this includes the court cost, cost of supervision, and surcharge.
How much is is just restitution, is that just the restitution?
Just the restitution? The restitution was paid off.
So there is no restitution owed?
No.
Your Honor, this time the state would move to dismiss the violation of probation, terminate supervision, and convert all outstanding costs to a civil lien unless she wants to be given a period of time to pay the remaining costs, Your Honor.
Do you understand what that means?
I have documents, but I can have the rest of this paid off by
Judge, may I?
the 12th of...
Yes.
Sorry.
How much time do you need, the judge may ask this, how much time do you need to pay those outstanding costs?
I will have it paid off by the 3rd week of May.
Okay, so if we just give 60 days, then well, that'll take care of it.
Yes, sir.
Okay,
Absolutely.
so with that, the state dismisses the VOP, probation is terminated, 60 days to pay outstanding fees and costs.
Correct, Your Honor.
Okay?
Go ahead and go to the court, and if that 60 days, looks like you're not going to have it totally paid, ask
I'm not going to be paid.
the judge for an extension, just in case.
Okay. All right. Thank you very much.
Thank
Good
you.
day.
Thank you.
Lucas Stevens.
Your Honor, may I approach the bench on Mr. Stevens?
Granted.
And if I could ask Mr. McKinney to come up there with me.
All right, so, Mr. Stevens, you're here today without an attorney. Do you want an attorney to help you, or would you like to hear what the state has to say first?
See what the state has to say.
All right, do you have an offer to settle Lucas Stevens, 23 CF 829, 23 CF 848?
Yes, with the state would request that this probation be extended as far out as possible on both cases, and ask the court to waive the cost of supervision so that he could pay the restitution, and I would ask the court to order a monthly, minimum monthly payment towards the restitution.
And so, what I'm understanding is that would be a modification in return for a dismissal.
No, I would ask the court to, it would be a modification, and then he could early term his probation as soon as all the financials are paid.
But that modification, you would then dismiss the VOP in return for the modification?
Correct, yes, sir.
Okay, do you understand what's being offered?
Yes, Your Honor.
And once your restitution is paid, then you could terminate, assuming you have no other violations. Are you in a position to do that?
Yes, Your Honor.
Okay. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do, Your Honor.
And so you heard that discussion. What amount of time does he have remaining available on his probation? Do we know?
I don't know the exact,
When's his present termination date?
it's scheduled to terminate May the 16th of this year.
All right.
And I know that I believe I need to find the, so he's placed on 2 years of probation, so he would have 3 left on, looks like we could extend it 3 years.
All right, so extend 3 years from the original termination date, waive the cost of supervision,
Yes, sir.
and provide a minimum payment towards restitution.
believe he needs some clarification, I guess, from the court.
The court order seems like it was modified. It says that there is to withhold adjudication, and I'm not sure that those charges are permitted to withhold any kind of adjudication. It's here on this back page. That's the order of probation. She might have just not have read the documentation correctly or not.
It would have been an adjudication of guilt.
That's what I understand. I mean, but with that being said, I've paid off my fines. I have a certificate of the counseling that was completed, and a recommendation from Patterson Professional that the rehabilitation wouldn't be necessary, that I wouldn't benefit. And with that being said, I've contacted all of the rehabilitation centers that was provided, and they will not accept anybody that is not actively using or addicted to drugs or alcohol. And I would just like to ask the state if we could waive the inpatient rehab, because I'm just not able to afford the cheapest rehab without insurance. It's $1,000 a day. That's $60,000.
No, I would not agree to that. That's the whole,
There's no inpatient rehabilitation in Okaloosa County. Bridgeway doesn't provide one. I mean, I have the recommendations from both the counselor and the completion of the requirement that Amber Browner had provided. She said that I would need those substance abuse evaluations.
But we got to get to the very first, what the narrative says is that the defendant has refused to sign the agreement, the order,
Yes.
and has refused to end process for probation and the support log. The defendant stated that due to his appeal, he is not going to sign the order nor his support log.
Okay, that's what was written, Your Honor, but I specified without the advice of an attorney because I wasn't sure of the withheld of adjudication that's written. I didn't know if, I just wanted a clarification. I mean, I'd sign the order, but I mean, I want to clarify, is there any of the order withheld? And as far as inpatient services, I mean, I wasn't given a guideline on that, but I was going to try to process the proper documentation with what I have from the counselors and the evaluational service to modify the probation of something that I just cannot afford. I mean, I have since completed everything asked to me within the documents and paid my court costs and fees. It's just I'm not accepted in those environments. I have a recommendation here. I do have proof of me with my sponsor with AA. And I've contacted all the treatment centers in the county, near the county, and they said Bayshore is $120,000 for 60 days. And they won't accept me unless the individual's actively struggling with the addiction. They just won't.
This is a case where he was charged with a 4th DUI, but it was actually a 5th DUI, and it was a negotiated plea to avoid going to state prison, and he agreed to do inpatient treatment in lieu of going to prison. And the state is not willing to
I don't know anything about that.
consent to just waiving that requirement. So
There was never an agreement of a prison sentence. There was none of that.
No, you didn't listen. He said that there was an agreement for a downward departure that avoided you going to prison because based upon the charge, you were facing prison. That's what he said.
The 21 months.
Yes, sir.
But I was on the scram monitor for close to a year.
Well, that doesn't matter. Your score sheet showed prison, and didn't go to prison because you had a negotiated plea agreement.
That was never, nobody ever said anything, that not my attorney at the time. He was just he had several different pleas that he was handing me. And then something about an outburst that I never even said anything while I was in court. And I think that was the guy ahead of me.
There were multiple times that Mr.
Well,
Stupar,
we're getting almost into a 3850. We're here on a violation of probation. He's refused to sign the order and refused to do the things that probation says, that the plea agreement says. So we can't get into those details, but that's the situation that we're presented with. There was a negotiated plea agreement that was a downward departure that avoided a prison sentence. That's what's before the court. You had a guideline prison sentence. There was a negotiated plea agreement that avoided that. One of the conditions is must complete inpatient treatment a minimum of 60 days or Keaton if eligible. After the inpatient treatment is successfully completed, then the defendant must complete the AA meetings per week, and there's no objection to some of those being virtual. That's what the plea agreement says.
I'm okay with that, but I'm not eligible, and I just, on the order, is this gonna need to be rewritten? Have you seen this? Mr. Stone? You haven't seen that?
What order needs to be rewritten?
It says, impositions of sentence is hereby withheld.
There's a scrivener's error on the probation order. It says adjudication of guilt, but then the wording.
And if I'm not eligible.
Right, the order says, okay, I'm looking at that. Direct me where, Madam Clerk?
I mean, I thought it was sweet. I mean, if I complete the probation, I wouldn't have 1 and 2 charges, of which I,
Docket entry 103.
That's the one I'm at.
but I know by law that those, at least the DUIs and
The court adjudges you to be guilty of the above offenses.
But this is now therefore it's order and judge impositions.
All right, so that needs to be corrected, because there's a scrivener's error in the order. You were adjudged guilty. That's what the plea agreement says, that you are to be adjudicated guilty. All right, so that needs to be corrected, probation. Now, but you do have a pending appeal.
I think that case was closed, Your Honor. I actually was requesting a withdrawal for the 1 and 2 charges with the intent, but apparently the attorney filed an appeal of the judgment or plea and sentence. But I have the emails that specifically asked, multiple phone calls. He just kind of did what he wanted, not what was in the best interest of the counselors and the mediation center, along with all 3 evaluations. I would like to talk with an attorney, just a better mediator
All
than
right, well,
myself.
you need to complete your affidavit then if you want a lawyer.
I'm not sure for a 68 program, and I know that there's one in Mobile that is, but the thing is the acceptance. So if I'm not using, if I could continue, I'm continuing, I've completed the evaluation and all the substance classes, but I'm continuing to go. I like the lady I'm in. Her and I, we talk, so.
Well, if you want me to appoint a lawyer for you, you're going to have to complete the affidavit and turn it in.
Sure thing.
And I'm looking now at the progress docket in the DCA, and the case remains open. And with initial brief filed, looks like on 3/26.
The recommendation from Jasmine Dixon, she was to file a 3850, and I don't have the means to file for a brief. There's just not enough information in there.
Well, yes, sir. We don't need to get all that, but
Okay.
there's an appeal pending, and so, but they violated you for failure to comply. We need an amended amended order of probation, which takes care of the scrivener's error, which says he's both adjudicated and adjudication withheld. And if you want a lawyer, complete the form and turn it in. Don't leave until you receive a new court date and you get your lawyer appointed, okay?
Yes, sir.
All right. And then I show we've got one in Mary Louise Guthrie. She present? She's incarcerated without counsel? Or do you have an appointment on that?
I believe that's going to be mine.
Guthrie, yes, Mary Louise Guthrie.
I believe she's an inmate.
Yes. Have you had contact with her?
I have not, Judge. I just
The
saw.
PD is appointed.
Yes, yes. Yeah, she's in.
All right, and so what do we, let's have Mary Louise Guthrie, please. She's not on the transport list. Is she in jail?
She was. You have Ms. Guthrie in the courtroom?
She's number 15. Number 15.
She is on the transport. Okay.
And I don't show Caden Stewart in the Zoom.
So if we could set him for May the 14th, could we do that, Your Honor?
That's fine. That's just one.
At 9,
That would be good. Yes, sir.
May 14th at 9.
And if I could briefly approach on that case with Mr. McKinney. On the
Well,
Stewart case.
let's take care of
Okay.
Ms. Guthrie here.
Judge, this is Mary Guthrie before the court, 21 CF 2550. This is violation of probation arraignment. We'd enter a denial and ask for this to be set next week without subpoena, so I have an opportunity to sit down and discuss her case with her at the jail. I have familiarized myself with the case, so I know that this is related to in a way. So I'd like to have an opportunity to discuss that with her and discuss the state's offer.
Okay. All right, and you have the state's offer?
I do. I have spoken to Ms. Leone, and she has provided me paperwork.
Okay. All right, very good. So we'll set it on 4/23, no subs.
So you'll come back next week, I'll come talk to you.
Okay.
If you want to approach on that.
If you don't. Let's go stand close to.
All right. William Vordebon. All right. And we're here today, I believe Mr. Vorderman's self-represented in this case and has filed a series of motions, and the court, and then had them set by the clerk. The motions are procedurally insufficient because they lack a proper statement regarding them being made under oath. So they should be dismissed without prejudice to file a procedurally correct motion. I'm not reaching the facts of the case or the legal issues in the case, but only they have to be procedurally correct. And then once they're procedurally correct, then the state has to be provided the opportunity to file a response to them. And that basically I issue an order to show cause telling the state to respond. But once they're procedurally sufficient, then the court will do that. So it would be my intention, unless the state wishes otherwise, to dismiss them without prejudice, providing you the opportunity within 60 days to file a motion that is procedurally correct, that meets the rules of procedure. And once that's done, then I'll issue the order to show cause to provide the state the opportunity to file their response, and then we'll set it for hearing.
Do I need to be on the oath or anything?
No, sir. Not at this point in time, because it's not my intention to proceed forward because the motion is procedurally not correct.
That's fair enough. Well, I'd like to bring a verbal motion of fraud in the courts. By my understanding, it can be brought up at any time.
Well, yes, sir, but we're not here for that. We're here because you set your motion for hearing today, and the court's reviewed that, and it's not procedurally correct, so we can't go forward. So I'll be dismissing the motion without prejudice, means you have the right to refile that to cure the procedural deficiencies. And once that's done, then I'll issue an order to show cause directing the state to file their response. Once they file their response, then we'll have the hearing where we'll conduct the hearing under oath with any of your folks that you believe are necessary.
This gets past my 2-year mark, though.
Past your 2-year mark?
Yes, sir. That I had to file for a vacate.
Yes, sir. Well, because I'm doing this without prejudice, essentially the date would revert to when you originally filed your motion. So that wouldn't preclude you from.
Okay, so you said in 60 days I can come back or?
Yes, sir. Yes, sir. This is different than me denying your motion. I'm not doing that. I'm simply saying it's not procedurally sufficient, and you've got the right to file a procedurally sufficient motion within 60 days.
Okay. How quick can I get it back in court?
Well, once you file your procedurally sufficient motion, then I'll direct the state to file their response, and once they file a response, then we'll set it for hearing.
Okay. All right. I'm not sure. Can I find out what's wrong with it procedurally?
Yes, sir. I'll be sending you a written order which details the specific procedural deficiencies. I reviewed that, made notes. There's a lack of a proper oath and jurat, those sorts of things that are not correct.
Okay, so I can't be heard though.
Oh, yes, sir. I'm not saying you won't be. I'm not saying I'm going to grant the motion.
Sure, I agree. Yeah,
but it needs to be procedurally sufficient. And like I said, you'll get a written order which says that and provides for you 60 days to provide a procedurally sufficient motion. And once that's done, then we'll move forward, okay?
Okay, thanks, sir.
Okay. You're welcome. Anybody else in the courtroom for their own case? Or are you here for somebody who might be incarcerated? Anybody else in the courtroom for your own case? Yes, sir, please step forward. Your name is, sir?
Collie.
Okay, and so we were set this for status today, correct?
So I can't remember, Your Honor.
Okay. And,
I believe Mr. Early, from what I was told by ASA Little, that Mr. Early is going to be coming from Pensacola today.
right, I see the note now that he'll be here after a little bit. He had court in Pensacola today, and there's been an accident on 98, so he'll be here shortly. Thank you, Mr. Collie. We'll get back to you as soon as he's here. Who else was that? Yes, sir? Or yes, ma'am? Your name is?
She was on with Mr. Nope, Your Honor. We had issued a KPS.
Okay. Yeah, Mr. Nopes was here earlier and indicated that you hadn't met with him as you agreed, and so, but you're here now, so,
Well, I'm supposed to meet with him on the 18th.
well, he said the 14th, and.
I thought it was the 18th.
Okay. So, but you got here late anyway, right?
I came from Pensacola.
Okay. All right. All right. Well, I'll withdraw the capias. Get in touch with Mr. Nopes right now before you leave the courthouse. Call him up.
Okay.
Since you're here, maybe he's got time for you today. If he doesn't have time for you today, I'm going to reset it for next Thursday at 9 o'clock. All right, but he's got to have be in touch with you and talk to you and be able to review the case with you to move the case forward, okay?
Okay.
All right?
All right, thank you so much. You said
Okay.
Thursday?
Say again?
Next Thursday?
Yes, 4/23, but you need to see Mr. Nopes before then, okay?
Okay, thank you so much.
All right. All right, was there someone else in the courtroom with a case of their own?
This gentleman on the front row has a
Yes, sir.
form.
Okay. Well, let's take 5 minutes now, and y'all line the cases up that you feel we can quickly dispose of, and then back the other cases up, okay?
All rise, please.
5 minutes. All right, Mr. Stupar, do you want an attorney to represent you? Did you complete the application?
Yes, sir, Your Honor.
All right, pass it to bailiff. All right, so you marked, you got the amount of income there, but you didn't mark if it's monthly, weekly, semi-monthly, yearly.
I just recently had a bunch of people reach out to me for interviews, and I started a job recently. I haven't been paid yet. I've been working at Mr. Destin's, Dewey Destin's, in Navarre, and it's a bi-weekly pay.
So you paid every 2 weeks?
About every 2 weeks. I'm not sure if I'll be staying there because there's a couple closer and better opportunities closer to my living arrangements. But like I said, I mean, it just, when it happens, it happens. Everybody reaches out.
And that's what you expect is your net?
I'm only going to be working roughly 20 hours a week. I've since applied for a SSDI, and that's the only allowance for me to be approved for that SSDI.
Okay. You do qualify, and the public defender will be appointed to represent you.
Thank you, sir. Is there a next court date?
Well, hold on just a second. We'll talk about that.
Yes, ma'am.
All right.
Did you have a question?
Yeah, the court date. And
What is the next court date?
Well, that would be up to you, Ms. Yeski. We can enter a denial at this point in time, and of course, you've heard me direct the probation to do an amended probation order, which corrects the issues regarding the adjudication. There is the pending appeal, and it's not clear to me, but that appeal is in case number 2025-3332. And what's interesting about that is, although I can see the case, it's not associated with me, and I'm not sure why. But the last thing was, an initial brief was filed on 3/26/26. It does look like that your counterpart in the second is appointed to represent Mr. Stupar and has proceeded with that, but that's as much as I can see because I can't see the docket because it's not assigned to this court, and I'm not sure why. But it is a notice of appeal of the final judgment and sentence. That's the best I can tell you.
Thank you. And Judge, we can look into the appeal and see what status is.
All right. And so, but you have the benefit of the violation at this point in time, and I think you've heard so we'll set it, is 4/23 going to be enough time for you to look at it? You want to move it to the first date in May?
If we could do the May date, that will give us enough time to meet at my office and discuss the case.
All right, very good. Madam Clerk, that would be
May 14th at 9 o'clock.
May 14th at 9 o'clock.
So come meet me in my office before this court date. Thank you.
All right. We're ready.
First will be Shannon Lock.
Shannon.
Judge, this is Shannon Lock before the court, 25 CF 1704. I'm standing in for Mr. Cochran, who's in the other room. Did you have a chance to read this through?
I was
Is there a fresh copy, or do you want me to mark this one up?
Nope, mark it up.
Okay. So you understand you're admitting the violation of probation. It's going to be 6 months. We'll call it Okaloosa County Jail. It's going to be revoked and terminated. You're not going to be in probation. You understand that? Okay. So you need to sign it and date it here. The agreement that's been reached with Ms. Lock and the state in 25 CF 1704 is to, today, 4/16/26, is to admit to the violation of probation, serve 6 months in the Okaloosa County Jail, that will revoke and terminate her supervision. She has reviewed a plea and sentencing agreement. May I approach?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay, you put your hand down.
No objections to the score sheet?
You heard what Mr. McKinney said, and you signed the written plea form.
Yes.
You understand by this plea arrangement that you're admitting the violation?
Yes.
That says, yep, I violated my probation just the way the affidavit and report says I did. In this case, you'll be adjudicated guilty. Your probation will be revoked and terminated. You'll be sentenced 6 months to county jail, credit for all time served. You'll have an additional $150 state-provided legal assistance, $100 cost of prosecution. You'll have your outstanding fees and costs that you'll need to pay. How much time will you need, do you think, to pay those once you get released?
I'm not sure.
Is a year okay, or you need more, you think?
Yeah, that's fine.
All right, year to pay.
Get on the payment plan.
All your questions been answered about the plea arrangement and how it affects you?
Yes.
You satisfied with how you've been represented?
Yes.
Now, look like you have a question, though. Okay. All right, the court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Next, we got Jessica Rogers.
Thank you.
Thank you, Your Honor. This is Jessica Rogers before the court in 25 CF 1640. We are here on an evidentiary hearing for a violation of probation. If I could just have one moment.
Yes, ma'am.
Your Honor, in this case, we have come to an agreement, and I will announce the terms at this time. It will be admit the violation, 11 months, 29 days in the Okaloosa County Jail, revoke and terminate probation, pay a $100 cost of prosecution in violation of probation, $100 cost of defense, and $50 public defender application. And I have the agreement, if I may approach.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir, I do. Yes, sir.
All right, I heard you. Yes, thank you, ma'am. You can put your hand down. You heard what Ms. Jeske announced on your behalf, and you signed the written plea form?
Yes, sir.
You understand that you're admitting the violation?
Yes, Your Honor.
And that says to me, yes, Judge, I violated my probation the way the affidavit report says it did.
Correct.
And you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
I violated, sir.
Okay. And you understand you're waiving your right to a hearing where the state would have to prove that.
That's fine.
All right. And in this case, you'll be adjudicated guilty if not previously, and you'll be sentenced to 12 months in the Okaloosa County Jail. And your probation will be revoked and terminated, and you'll have the additional fees and costs that were announced. How much time will you need to get everything paid once you're released?
Your Honor, I would like at least 6 months to a year, if you could.
Okay, a year to pay is sufficient. All right. All your questions been answered about the plea and how it affects you?
I only want to make sure, absolutely certain, that this is running coterminous and all credit for time served. All credit for time served, that's the correct.
Credit for time served, I don't know about coterminous because I don't know about any other case.
There is no other case, I'm just ignorant to the law.
Okay, yes, it is credit for time served, and so any time that you have on this arrest or prior arrest would, on this case, would go towards your credit, towards the 12 months.
Thank you, Your Honor.
Okay. All right, I find the plea to be freely and voluntarily entered into, and I'll accept the plea. Thank you.
Thank you. Thank you, Molly. Have a good day.
Next we have Natasha Zespal.
Judge, this is Natasha Zespal before the court. She has two things going on. She has 25 CF 2060, which is a violation of probation. That was actually pled with mental health court as a condition. So my understanding is that that should remain on the mental health court docket. She was seen yesterday in mental health court, and they reset a court date for the violation of probation there. She also
is on our docket, but I'm not sure why. Madam Clerk, you see that?
It just happened yesterday, probably just.
Okay, and then we got the 2061 case, right?
And then there's a 26 CF 618, which is on the arraignment docket in May. The only thing I have on my file is the 26 CF 2060.
All right, so I guess, but I also had the 25-2061. I guess maybe one got moved and the other one didn't?
I'm unsure, Judge. You only went in on the one case number, right? No, that's a separate thing. Okay, no problem.
And say 2026 CF, what's the new case?
618. And that is set for arraignment 514.
Okay. All right, so we really don't need to take care of anything today for this, correct?
Correct. I think it just needs to remain on the mental health court docket. I believe there's already a court date set for that. When you
Okay.
For May 6th.
Very good. Thank you very much.
And Judge, I believe that the 2061 case was handled when we entered the plea into mental health court. And that was time served on that case, so we shouldn't need to do anything with the 2061.
Okay. Say again?
The one only listed 2060.
Correct.
Okay, all right, very good, thank you.
Then we just stay on the arraignment docket on 514 for the
Correct.
26 CF 618.
Correct.
Next, I have Naomi Perez.
This is Naomi Perez before the court in 24 CF 910. We have come to a resolution in this case. We're here for a violation of probation. The terms are admit the violation, maintain withhold, reinstate to standard probation to complete the original requirements, and modify to make the next 6 months of probation on community control. This will include the $100 cost of prosecution, $100 cost of defense, and $50 public defender application. And the agreement has been signed by all parties, and I have the score sheet as well, if I may approach.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you put your hand down. You heard what Ms. Yesky said?
Yes, Your Honor.
Extra page. And signed the written plea form.
Yes, Your Honor.
You understand that you're admitting the violation?
Yes, Your Honor.
And that says, Judge, I did violate it just the way the affidavit report says it did.
I was working, yes, Your Honor.
Yes. And you understand by doing this, then you're waiving your right to a hearing where the state would have to prove your violation.
Yes, Your Honor.
And in this case, the adjudication will continue to be withheld, and you reinstated the original requirements, but the next 6 months is community control.
Yes, Your Honor.
And you'll have the additional fees and costs that were announced.
Yes, Your Honor.
Ms. Yesky answered all your questions about the plea and how it affects you,
Yes, Your Honor.
and you're satisfied with how you've been represented.
Very, Your Honor.
All right, the court will find the plea to be freely and voluntarily entered into and will accept the plea. All right, thank you very much. Good day.
Casey Williams.
Judge, we've reached an agreement with Ms. Williams. I could write that up and make it quick, or we could call her back in just a moment.
Well, it's to a VOP, right?
Yes, Judge.
Go ahead and do your writing. Let's get her done while she's here.
And I have discussed this fully with Ms. Williams, so she knows exactly what we're talking about and what to expect. The agreement is for her to admit to the violation of probation. She will be adjudicated guilty. Previously, this was a withhold of adjudication. She will serve 10 months in the Okaloosa County Jail with credit for time served, and that will revoke and terminate her supervision. That will be with a $100 VOP fee and a $150 cost of defense. Now, we have previously looked at VOP forms before. Okay, do you have any questions of me related to this form that you are going to be signing? That's a maximum for that, for any third degree felony is a maximum. That's good. It's not, nothing to be being sentenced to. Okay. You're being sentenced to 10 months of Okaloosa County Jail for time served for terminating probation. No VOP hearing by any this plea. You can sign it. Yes, and you'll be able to have a copy. If they. 4/16/26. Okay. Okay, any questions for me? Okay, Judge, may I approach?
Granted.
Judge, we have agreed on a score sheet. Mr. Snell is going to prepare that and present it to the court in just a few moments.
Raise your right hand, please.
This is a guideline sentence.
Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir, I do.
All right, you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
You understand by this plea arrangement that you're admitting the violation?
Yes, Your Honor.
And that tells me, yes, Judge, I violated the way the affidavit report says I did.
Yes, Your Honor.
And by doing this, do you understand you're waiving your right to a hearing where the state would have to prove your violation?
I do, Your Honor.
In this case, you'll be adjudicated guilty if not previously. You'll be sentenced to 10 months in the county jail, credit for all time served. Your probation will be revoked and terminated. You'll have the additional costs. How much time will you need to get everything paid once you're released?
Ask for a year.
A year.
Okay, a year to pay. Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfied how he's represented you?
I am.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you.
Next will be Naomi Perez.
Oh, sorry. Disregard.
I have one in the courtroom, Your Honor, that's going to be a plea. We have Ms. Burns approach.
All right.
This is case number 23 CF 1805, Your Honor.
All right.
Your Honor, we've reached a resolution in this case. In exchange for an admission of the violation, the state has agreed to maintain the withhold, modify the probation by extending 1 year, and that term will auto-terminate upon completion of her drug treatment.
All
There will
right.
be court costs, cost of prosecution, cost of defense.
All right.
I have the signed plea form and the score sheet, if I may approach.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you put your hand down. You heard what Mr. Cochran said and you signed the written plea form?
Yes, Your Honor.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, Your Honor.
That tells me, yes, I did violate my probation the way the affidavit report says I did.
Yes.
And by doing this, you understand that you're waiving your right to a hearing where the state would have to prove your violation. In this case, adjudication will continue to be withheld. You will modify your probation, so extend it for a year, and it can terminate as soon as you finish your treatment, and you've got the fees and costs that were announced.
Your Honor, I would ask waive the cost supervision for the remaining year.
COS is waived.
Thank you. You don't have to pay cost supervision.
All right. Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, Your Honor.
Satisfied with how he's represented you? Court will find the plea to be freely and voluntarily entered into and will accept the plea with a continued withhold. Now check in with probation before you leave, okay?
Your Honor, if I
Mr. Early, you ready?
I am ready, Your Honor. We've got a plea agreement here for Mr. Emanuel Collie. Mr. Collie is making his way to the podium. Your Honor, it is for an adjudication of guilt, 364 days county jail with a total of 749 days credit, 870 in court cost, $150 public defender fee. If I may approach, I got the plea agreement and score sheet.
Granted. You're welcome.
I appreciate you waiting on me.
No, sir. Like I tell everybody, as long as I know, and you did the right thing, and it was in my notes, so I knew that you were going to be tardy. There's no problem.
I was more late than I wanted to be. In 2 words, you'll probably understand Patrice Cashwell. So.
I thought you were going to say bloody 98, the 2 words, but you know.
Oh no!
Because I know there was
that was a safe drive. That was smooth. That was super quick.
All right. Is this the state's agreement?
It is, Your Honor.
All right. And no score sheet objections?
None from the defense, Your Honor.
All right. Raise your right hand, Mr. Collie. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay. And you put your hand down. You heard what Mr. Early said. You signed the written plea form.
Yes, sir.
How old are you?
I'm 29.
How much school do you have?
10th grade.
All right, you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what Mr. Early just told me it contained within the plea form.
Yes, sir.
You understand you're pleading no contest to these charges?
Yes, sir.
That tells me that you believe the state has the evidence to prove your guilt to the jury, and you're not going to contest that.
Yes, sir.
By doing this, you understand you're waiving your right to a trial by jury where the state would have to prove your guilt.
Yes, sir.
And you'll be adjudicated guilty, sentenced to the 364 days in the county jail with credit for time served with the fees and costs that were announced. How much time are you going to need to get those fees and costs paid?
6 months to a year, Your Honor.
So you want me to give you a year?
Yes, sir.
All right, 1 year to pay. Mr. Early answered all your questions about the plea and how it affects you?
Yes, sir.
Satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. If you'd step over this way, please.
Thank you, Your Honor. No further business.
Thank you, Mr. Early. Good day.
Are we ready for Mr. Perez?
All right.
Laura sells?
Settles?
Sells, like she sells seashells?
Oh.
By the seashore.
That was good. That was
Your Honor,
good.
I'll just need one moment. This is Laura Sells before the court in 26 CF 575 and 25 CF 1101. We've come to an agreement in both cases, and I will announce the terms. In 26 CF 395, it will be an adjudication of guilt, 3 years of probation with the special condition to complete the Keaton treatment program, which will be a bars to bed, waive the cost of supervision, maintain gainful employment, or submit 3 applications per week, no drugs or alcohol, without prescription, court costs, cost of defense, and the state will take no action on the failure to appear. And for the record, the probation requirements will go into effect after the Keaton treatment program is completed. In 25 CF 1101, it will be admit to the violation, adjudication of guilt, reinstate and modify probation to bars to bed Keaton treatment program, and the probation will terminate upon completion of Keaton, waive the cost of supervision, be $100 cost of prosecution and violation of probation cost of defense, and complete original requirements.
You would have to roll whatever her remaining requirements are from the probation if you want to turn it into a new term. How that would work. Does that make sense?
Sorry. Your Honor, if I may have a moment to modify the agreement. Your
All right,
Honor.
so we'll move this to the afternoon to give the state the opportunity to get their information filed, and then we'll take the plea.
Thank you.
Marcus Thompson.
Judge, this is Marcus Thompson before the court. He has two things going on. He has his violations of probation, and he also has a new law case in 26 CF 579, which is set on 423, but an information has been filed in that case number, so I'd like to do the arraignment today in the 26 CF 579. I'd like to enter a denial to the violations of probation.
So is he on the docket? There he is.
He's on the docket.
For the 1938-12, and, all right.
He's on the docket in several different places to make it fun.
All right, and so we have the new case, and say again the new case?
The new case number is 26 CF 579. She did. Yes, hold on. One thing at a time.
All right. And so information has been filed. You confirm that, Madam Clerk?
That's what she filed. That's a copy for you. The state did file a 2-count information.
We'll leave that on for 511, or?
Judge, I'd like to leave it on 511. I'd like the violations of probation to track with that, with a denial entered.
So you gonna fight this with me, right?
Heck yeah. Heck yeah.
All right, set all the cases to track together, and we'll set, enter not guilty on the 26-579, and set the cases to run together for 511.
Yes, Judge.
Okay, I put it down.
Thank you, Judge.
Randy Williams.
Judge Randy Williams is before the court. He's here in 3 case numbers, 24 CF 2057, 24 CF 2508, and 24 CF 2707. This is a violation of probation arraignment. For today, we're going to enter a denial. I'd ask for this to come back next week. We are awaiting some correspondence from Phoenix House, and that will potentially impact the discussions with the state. So that would be 423.
Yes.
Thank you, Judge.
Good day, sir.
Next we have Darius McNap. McNap?
1 second, Your Honor. McNab has the case this morning. He also has a case that's on the arraignment docket this afternoon. That case number is 26 CF 0602. He's going to enter a plea today to both cases.
I'm sorry, say again that case number.
Yes, sir. It's 26 CF 0602.
Okay.
Just one moment for signatures.
That plea agreement addresses the three cases, right?
There's 26 CF 472 as well.
Yeah.
Same offer.
Yeah, it's the same terms.
472, 25, 24, 39, and 26, 602.
Do I get credit for all time served? Yes.
Yes. Credit. Yeah. There is a third case here that I did not write, Your Honor, if I have one moment.
Yes, sir.
Okay, so all I did was add the other case, VOP, the petty theft, that case, count one, open term, 9 months county. All right?
Credit for all time served?
You get credit for everything you did.
Okay, all right.
All right.
You got this question? I got it.
Sorry about that, Your Honor.
That's all right.
All right, let's try that again, Your Honor.
I got it.
Now we have Mr. Darius McNap, Your Honor. I'm going to put these case numbers on the record again. We have case number 25 CF 2439, 26 CF 0472. Those are both here for violation of probation. And then we have 26 CF 0602. That case is here. It's on today's arraignment docket, but information has been filed and we will be entering a plea today. On case number 25 CF 2439 and 26 CF 0472, we will be admitting the violation. It'll be a term and revoke probation, 9 months, Okaloosa County Jail. court costs and cost of defense to both cases. And then 26 CF 0602, that will be a plea of no contest, adjudicate guilt, 9 months, Okaloosa County Jail, court costs and cost of defense. I have the signed forms and score sheet if I may approach.
Granted. Raise your right hand, please. Do you swear or affirm to, the other hand, there you go. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Is that yes?
Yes, sir. I'm sorry.
All right, that's okay. You can put your hand down. You heard what Mr. Cochran said and you signed the written plea form.
Yes, sir.
All right, you got two things going on. You got your VOP and your new charges. You understand that?
Yes, sir.
We're taking care of them together, but they're two separate things, right?
Yes, sir.
As to your VOP, do you understand you're admitting the violation?
Yes, sir.
And that tells me, yes, Judge, I violated the way the affidavit report says it did.
Yes, sir.
And do you understand by making this plea, you're waiving your right to a trial where the state would have to prove your violation?
Yes, sir.
As to the new charges, do you understand you're pleading no contest?
Yes, sir.
And that tells me you believe the state could prove your guilt to a jury and you're not going to contest that.
Yes, sir.
And by doing this, you're waiving your right to a trial by jury.
Yes, sir.
The arrangement here is your probation will be revoked and terminated, and you'll be adjudicated guilty. And on your new charges, you'll be adjudicated guilty. And you're going to serve 9 months in the county jail, credit for all time served with fees and costs. And those are on the new case. What would they be, Madam Clerk?
515 court costs, $100 public assistance fee.
All right, and then the other case, you're going to have $200 cost of prosecution and $250 state-provided legal assistance. How much time do you think you'll need to get all those things paid once you're released?
At least a year. Yeah, at least a year.
A year to pay. Mr. Cochran answered all your questions about the plea and how it affects you.
Mm-hmm.
Is that yes?
Yes, sir. I'm
Are
sorry.
you satisfied with how he's represented you?
Yes, sir.
I'll find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Your Honor, this is going to be a plea, if I just have one moment to get signatures.
And what's his name?
Mr. William Boyd, case number 20 CF 2803.
All right, thank you.
We have Mr. William Boyd, Your Honor. Today, we have entered an agreement with the state. In exchange for admission for the violation, the state has agreed to maintain the withhold, modify probation to convert the next 12 months to community control, the remainder of probation to go on regular probation, maintain all previous conditions, any court costs, cost of prosecution, and cost of defense. I have the signed form and plea sheet and score form, if I may approach.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
You can put your hand down. You heard what Mr. Cochran said and signed the written plea form?
Yes, sir.
You understand you're admitting the violation?
Yes, sir.
That tells me you agree that you violated just the way your officer says you did.
Yes, sir.
You understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
All right, in this case, adjudication will continue to be withheld, and you're going to convert the next 12 months into community control, and after that, you'll revert to regular probation. You'll have the additional fees and costs. Is that your agreement?
Yes, sir.
Mr. Cochran answered all your questions?
Yes, sir.
Satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Next we have McQueen.
Your Honor, he's on the 2 p.m. docket. This is going to be for a plea, though.
All right. That's the acronym we use. Yeah, they're all concurrent. If I have one moment, Your Honor, sorry.
Yes, sir.
We have Mr. Eric McQueen, case number 23 CF 2907. We have reached an agreement with the state, Your Honor. In exchange for admission of the violation, the state has agreed to admit term and revoke and 36 months Department of Corrections. It'll be, he will get credit for any other time that he's previously served, and the counts will run concurrent.
And Your Honor, that agreement is a downward departure for the purposes of a legitimate uncoerced plea bargain.
If I may approach, Your Honor.
Granted. Raise your right hand for me, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
You put your hand down. You heard what Mr. Cochran said, and you signed the written plea agreement.
Yes, sir.
Do you understand by this agreement that you're admitting the violation?
Yes, sir.
And that tells me, yes, Judge, I agree, I violated the way the affidavit and report by my officer says I did.
Yes, sir. Judge, I agree to.
All right. You understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir. I do.
In this case, you'll be adjudicated guilty, sentenced to the 36 months of Department of Corrections. Your probation will be revoked and terminated. You'll get credit for all time served, and you'll have the fees and costs that were announced. And I'll give you 24 months after your release to pay those costs. Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
And you satisfied with how he's represented?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you, Your Honor.
Next we have Marlo Brown.
Your Honor, I am working towards a resolution with the state on this. So as for today, it's a VOP arraignment, Marlos Brown, 21 CF 2753. We'd enter a denial at this time, Your Honor, but I'd ask to set this for next Thursday with the understanding that we might have a resolution by then.
No objection from the state, Your Honor.
No subs, right?
No subs.
Okay, very good.
All right,
See you next Thursday. Good day.
Yes, sir. Judge, may I approach?
Granted.
Yeah, we're ready, Your Honor. We have Mr. Tommy Lawson, 25 CF 0467. I believe the state has an announcement.
Yes, Your Honor, this time, because the defendant has paid all of the restitution, we would announce a dismissal of the VOP and a termination of probation. And the outstanding court costs or monetary obligations, I'll let Mr. Lawson speak on how many days or months he may need to pay those off, but in terms of the VOP, we would dismiss the VOP, terminate probation.
Yes, Your Honor. As for, there's two parts to the cost. There's arrears for cost of supervision. I would ask, my client just paid over $1,500 of restitution. I would ask that the arrears be waived.
The cost of supervision arrears?
Yes, Your Honor. Sorry. Cost of supervision arrears. As far as court costs, Your Honor, I'd ask for 24 months to pay any outstanding cost.
I'm showing 2 cases on the docket.
Yeah, so.
Oh, yes, I'm sorry. The other case is 25 CF 0468.
The same thing.
It's the same resolution, Your Honor.
And so that's a dismissal of the VOP with this, is that what we're doing? Just to restate, to be clear?
Yes, Your Honor.
Okay.
Terminating, we would terminate probation in both cases. I just want to make sure it's clear for the record that we're dismissing both of the violations for both cases and terminating supervision for both cases as well.
Okay. So the VOP is dismissed, supervision is terminated, cost of supervision are waived, including arrears. The defendant has 24 months to pay.
Correct. Yes, sir. Thank you.
All right, thank you.
Thank you, Your Honor. Right back.
Next we have Eddie Lewis. Lewis.
right, Your Honor, we have Mr. Eddie Lewis, 24 CF 2716. Your Honor, today I'm going to enter a denial. Your Honor, I enter a denial and ask to set this for next court date.
All right. And with or without?
Without.
So next week?
No,
Yes, next week, please. I'm gonna do community control.
Give me 2 weeks, Your Honor.
Well, I've got next week, and then we go into,
Please.
Yes. We go into May the 14th, right?
Next week, please.
14 for 423.
Next week, please.
I'll set it for 423 if I have a we may have a resolution.
All right, 423.
All right.
Appreciate it.
Yep.
Next we have Malone.
One moment, Your Honor.
Yes.
Say your first name again. Rodriguez. Your Honor, we have Mr. Rodriguez Malone, case number 22 CF 1687. Your Honor, today we're going to ask for denial and ask for the May court date, May 14.
All right. 514.
Okay. 514.
It's without subs, Your Honor.
That's
No
without
subs,
Yeah.
right?
Bye-bye. I believe that completes my morning docket, Your Honor.
Charles Keith.
Yeah, this is Charles Keith, this one reports 18 CF 9. We've reached an agreement. Do you have any questions?
No, sir.
Mr. Keith is going to admit to the violation of probation. He will be adjudicated. Previously, this was a withhold. He'll be sentenced to 90 days in the Okaloosa County Jail with credit for time served. That will revoke and terminate his supervision. There will be $100 BOP fee, $150 cost of defense. May I approach with that plea agreement?
Yes.
And this will be a guideline sentence. We will need to prepare a sentence score sheet.
All right, raise your right hand for me, please. Do you swear affirm, testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your head down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
You understand you're admitting the violation?
Yes, sir.
Tells me you agree with your officer that you violated your probation.
Yes, sir.
By doing this, you understand you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
You'll be adjudicated guilty, sentenced to 90 days county jail, credit for all time served. Your probation will be revoked and terminated. You'll have the additional fees and costs. Is a year enough time to get everything paid after you're released?
Yes, sir.
Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
Satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
Step over here with me. Pay attention, pay attention. Step over here with me.
there Mr. Pierce here? You're right this way, Mr. He was on the 1:30 docket, but was asked to come early.
All right, give Madam Clerk a chance to get their Pierce.
This is Mr.
Peer.
Eric Peer before the court
Peer,
in
okay.
26 CF 419.
Yes.
Your Honor, at this time, the state is going to announce a no pros of this case based on a request by the victim to drop the charges and decline the prosecution. Yes, sir. And the victim is present in the courtroom, just for the court's awareness.
All right, case is no prost.
Next we have Christopher Carpenter.
got.
Recently.
I haven't got the one you sent recently, but I'll look for it, and I'll come talk to you beginning of next week. Okay.
Next, we have Emanuel Rivas.
Your Honor, this is Emanuel Rivas before the court in 26 CF 593 and 25 CF 1410. This case will be going into drug court. Mr. Rivas has been accepted, and I spoke with the coordinator who's working on getting his Santa Rosa County cases transferred into Okaloosa County, and that is the only holdup. Hopefully it'll drop off your docket soon.
All right, do we know those cases? Is there an agreement from the state to do that?
From what I understand is that I don't know about the prosecutor in Santa Rosa. I don't have that answer, if that's the court's question to me.
The coordinator informed me that she's working with the state attorney in Crestview to connect with that prosecutor, but yeah, we could also have you reach out to them as well.
I can do that, but I didn't know that was an issue. I thought
Well, please approach. All right, we'll set it for status of 514, and hopefully all those details will catch up with that.
Thank you.
Thank you.
He's up next. Thomas Cole. Sure.
Judge, this is Thomas Cole before the court in 23 CF 851. And Judge, Mr. Cole is here on a violation of probation arraignment. I'd like to enter a denial and ask for this to be reset for next week so I could communicate with the state. I did see that this was reassigned, or this is in your division. Originally, this was in front of Judge Clark. Originally, or in the original sentence, there's a 10-year suspended sentence. There are matters I need to discuss with Ms. Leone before we can really put a whole lot on the record here.
No subs?
No subs.
All right. 423.
Okay.
Thank you. Next is Quon Pernell. Pernell?
This is Quon Pernell in front of the court. We have on today's docket for the violation of probation 23 CF 2186. He also has what I believe is his arraignment today at 1:30 in 26 CF 529. And then another case set for May 14th in 26 CF 609. Your Honor, at this time, we would like to deny the violation, plea not guilty in 26 CF 529, and have all of these cases tracked together on the May 11th court date.
529, you say? Is it 26-529?
Yes, Your Honor.
Yes.
I think there is. Checking right now.
And that's not guilty on the new charge, and then,
Yes, sir.
is it already set on 5/11, Madam Clerk, or is it another day?
It is already set to 5:11.
All right, we'll leave it set on 5/11.
Your Honor, can we go ahead and also, I filed information on the 609 case. Can we have that track on 511 too, just so these are all together instead of waiting until 514?
So there's 26,
There's 26 CF 609, 26 CF 529, and then this 23 CF 2186.
That's correct.
plus the VOPs, right?
There's only just one, there's one VOP case.
And what's that case number then?
23 CF 2186.
Because I also have the 24-164.
I don't have that case, but if you'll give me a moment, I can look up, see what's going on with it.
Your Honor, that is Quon Pernell. That is a different person.
That's my son.
Yeah.
So, okay. Okay. All right.
I think, just for the record, I think that they need to go ahead and deny, acknowledge receipt of the information in 26 CF 609. Go ahead and enter a plea of not guilty so that we can then formally set that for the 511 date as well, Your Honor.
All right, we'll set that on for, and so the denial on the underlying. All right.
The underlying is 26, or, I'm sorry. Yes, denial in 23 CF 2186, and then enter a not guilty plea in 26 CF 529 and 26 CF 609.
All right.
And there is an information in both those cases.
And so the 164 is the other person, right?
Correct, Your Honor.
And sir, my frustration is not at you, it's at this computer that's not always doing what it should do. So my frustration is not about you, okay?
No worries.
All right. All right. All right, thank you very much.
Thank you.
You will not be here back at 1:30, right? Next is Trayvon Reed.
How y'all doing?
You will not need to come to the back at 1:30. You can take a rest.
Your Honor, this is Trayvon Reed before the court in 24 CF 2358. We're here on a violation of probation, and we've come to an agreement in this case. It will be admit the violation, reinstate standard probation, and modify to include 6 months of community control. In addition, the probation will extend by 12 months beyond the original termination date, and the conditions of resuming the anger management course in the first 30 days, enrolling in the advanced driver improvement course in the first 60 days, enrolling in the victim impact panel in the first 120 days, and reimpose all original requirements, which will include costs. And I have this agreement.
Grant, please approach. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Ms. Yeski said on your behalf and signed the written plea form.
Yes, sir.
All right, and you understand that you're admitting the violation?
Yes, sir.
And that tells me, yes, you agree that you violated the way your probation officer says you did.
Yes, sir.
And by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
And you'll be reinstated to your probation with the first 6 months of community control, and then extending your total probation for an additional 12 months with completing all the original conditions and resuming the course within 30 days and finishing enroll in the victim impact within 120 days, and then have the additional fees and costs that were discussed. Is that what you understood?
Yes, sir, I understand.
All right. And all your questions been answered?
Yes, sir.
You satisfied how you've been represented?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea.
Mr. Myers, sir?
Yep, you can keep that. Thank you.
Granted. All right, we got Sal's information now. There you go.
Judge, next up is Henry Reeves.
Reeves.
Your Honor, this is Henry Reeves before the court in 20 CF 2227. We have come to an agreement in this case. I would just need a moment to have the party sign.
Yes.
Again, Henry Reeves before the court in 20 CF 2227. This will be an admission to the violation of probation, serve 36 months in the Department of Corrections, waive credit prior to the date of the violation of probation arrest. It'll be a $100 cost of prosecution and violation of probation cost, $100 cost of defense, and a $50 public defender application. If I may approach with the signed agreement and the score sheet.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
You can put your hand down. You heard what Ms. Jeske said and you signed the written plea form?
Yes, sir.
Do you understand by this plea that you're admitting the violation?
Yes, sir.
And that tells me that you agree with your probation officer that you violated your probation the way the affidavit report says you did.
Yes, sir.
Do you understand by doing this you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, you'll be adjudicated guilty. Your probation will be revoked and terminated. You'll be sentenced to the 36 months in the Department of Corrections. And an important part of this plea is that you're waiving credit prior to the date of your arrest. Do you understand that?
Yes, sir.
And ordinarily, folks are entitled to all credit for time served But I read this to say that you and the state have reached the agreement for the 36 months based upon your agreement to waive your credit prior to your arrest at this time. Do you understand that?
Yes, sir.
And do you agree to that?
Yes, sir.
Then you'll have the additional fees and costs that were announced. What amount of time? It is with a revoke and terminate, correct?
Yes.
How much time will you need to get everything paid once you're released? Is 24 months enough time, you think?
Yes.
Okay. Now, has Ms. Yeski answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how you've been represented?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Yes, sir.
Judge, next up is Sean Williams Sasser.
No.
Rest of it.
Your Honor, if we could have a moment.
Yes, ma'am.
Your Honor, we've come to an agreement in this case, and a score sheet will also be handed in momentarily. Okay, so in 26 CF 572, it will be plea to the amended charge of felony battery, a withhold of adjudication, 3 years standard probation.
Silence those phones, okay? Although I like that ringtone, I'm just saying. And it's 26 CF 572?
Correct.
And you have that, Madam Clerk? And we have an information? Okay.
50 hours of community service work, substance abuse evaluation within the first 30 days, and treatment within 60 days, no contact with the victim, maintain gainful employment, or complete 5 applications per week, court costs, and the cost of defense. This will be in addition to 23 CF 411 and 23 CF 381, which are the felony violations of probation that we're here for today. In those, it'll be the same exact terms, same terms for both of these. Admit the violation, maintain the withhold of adjudication, reinstate standard probation, as well as all outstanding requirements, credit for time served, the $100 cost of prosecution and violation of probation cost, and a $100 cost of defense. And then all those sentences would run concurrent. And I have the signed agreement.
What was the adjudication on that case?
It is a withhold of adjudication on all three.
Okay, and if y'all would approach, please. All right, raise your right hand for me, please. You swear affirm to testify truthfully in this matter under penalties of perjury.
Yes, sir.
All right, you put your hand down. You heard what Ms. Yeske said, and you signed the written plea form.
Yes, sir.
How old are you?
21.
How much education do you have?
11th grade.
Are you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read, what Ms. Yeske just announced to me.
Yes, sir.
Now, you've got two different things going on, right? You've got your violation of probation, and you have your new charges. We're taking care of them together, but they're two separate things.
Yes, sir.
Do you understand that?
Mm-hmm.
Is that yes?
Yes, sir.
Okay. As to the violations of probation, do you understand that you're admitting the violations?
Yes, sir.
And that says to me that you agree that you violated your probation the way your probation officer says you did in the affidavit and report.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
As to your new charges, do you understand that you're pleading no contest to the lesser included charge?
Yes, sir.
And that tells me you believe the state has the evidence necessary to convince the jury of your guilt, and you're not going to contest that.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
All right. You're going to be, adjudication will be withheld, and on your violations, you're going to be reinstated to all your outstanding requirements,
Yes, sir.
and you'll have the additional fees and costs that were announced.
Yes, sir.
As to the new charge, you'll be sentenced to 3 years of standard probation with the community service hours, the evaluations, and the treatment if suggested. No contact with the victim. You must get employment or seek employment, and if, as an alternative to that, you want to seek education or training, then I'll consider that to meet that requirement, and you can talk to probation about that. The
Yes, sir.
goal would be, if you're doing something that's going to set you up for successful employment, then I'll support you for that, okay? But they'll explain to that together with fees and costs. Is that what you understood your plea to be?
Yes, sir.
Has Ms. Yeske answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how you've been represented?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you.
Thank you.
Next up is Philip Saunders.
Thank you so much.
Saunders, you say?
Yes, Judge.
Your Honor, this is Philip Saunders before the court in 26 CF 122. This is a bond hearing based on a bond motion that was filed previously on March 18th of 2026. If I could just have one moment.
Yes.
Thank you. Thank you. Your Honor, first, I would like to offer testimony from my client, Mr. Saunders.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, I do, Your Honor.
No, but before we get there, help me understand that we're talking, just to be clear, this is 26 CF 122.
Correct.
And what I'm seeing is that there was a motion, there was a bond posted, and then it looks like his bondsman surrendered him.
Correct.
But, and it's not clear to me, the bond motion was, it looks like the surrender took place, it was filed with the clerk on 3/26. But it's not clear to me based upon.
If I could.
It looks like the surrender was on 3/24, but I don't see a bond motion subsequent to that. That was when I reviewed for the docket for today, that was my confusion.
Yes, Your Honor, my understanding is this is the sole motion. Mr. Saunders is unable to work with a bail bondsman due to the fugitive from justice hold. That hold is out of Virginia, and today would be the 33rd day of that hold. And he's still here before the court.
Okay.
So if that hold is released, typically 30 days, then he would just be here without the hold on this $2,500 cash or professional bond. And in this motion, we're asking for a ROR, release on own recognizance bond.
Well, okay, well, please approach.
Thank you, Your Honor, for that time.
You're welcome, Ms. Yeski.
At this time, we would request a continuance of the bond hearing in order to clarify some things on the out-of-state hold.
All right, so what I'll just do is I'm going to move it, I'm going to take it off the docket, and you can simply decide when you wish to have it renoticed instead of setting it for another date. That way, when you're ready, you can simply ask the clerk to set it, and we can move forward from there. And if that requires an amendment to your motion or whatever, or bringing something else in, that way you can take care of it all at once instead of setting it again, and so I'll leave that up to you.
That works. And the case is set for May 11th, 2026.
All right, very good. Thank you.
Thank you.
Thank you, Your Honor.
You're welcome, sir. Good day.
Yes.
All right, sir. Lawrence Rodriguez.
Rodriguez.
It's on the pre-trial detention docket.
Yes.
Okay. All right.
Your Honor, this is Lawrence Rodriguez before the court in 26 CF 717. We are here today for a pretrial detention. However,
Yes, Your Honor. The state intends on filing a motion for pretrial detention, and I can anticipate that I will have it filed by tomorrow, close of business. I didn't have enough time. Well, this morning we just got in contact with the victim, and she resides out of state, so I'm going to ask the court for a continuance to next week to go ahead with the hearing and assure the presence of the victim.
and we have no objection to that continuance. This was a very quick turnover.
All right, we'll set it for 4:23 at 12:30.
Thank you, Your Honor.
Thank you.
Your Honor, we have some gentleman from the 130 docket that's been sitting here for a few minutes.
Say again?
I got someone from the 130 docket,
Okay.
unless the court wanted to.
Yeah, go ahead and call him up.
Mr. Wayne Taft.
Taft, please.
Is he done?
No information is filed.
Your Honor, since there's no information filed, would ask to set this for continuance to next week to 4:23.
Reset for 4:23. Thank you.
Thank you.
Judge, if possible, we can get Laura Sells with Ms. Geske.
Laura Sells, please.
Thank you.
That's okay. All right. Ms. Yeske with Ms. Sells. We have now the information.
Yes, and again, Laura Sells before the court in 26 CF 575, 25 CF 1101. We have a complete signed agreement, if I may approach.
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. All right, so you've signed the written plea agreement in this case, and you have two different things going on. You have violation of probation, and you have your new charges. You understand that?
Yes.
All right. How old are you?
99.
How far did you go in school?
High school diploma.
Are you able to read and understand the plea form?
Yes, ma'am. Yes,
Did
sir.
you do that before you signed it?
Yes, sir.
Do you understand by the terms of this plea arrangement that you're pleading no contest to the new charges?
Yes.
And that tells me you believe the state can prove your guilt to a jury and you're not going to contest that.
Yes.
Do you understand by doing this you're waiving your right to that trial by jury?
Yes.
As to your violation of probation, do you understand you're admitting the violation?
Yes.
And that tells me that you agree with your probation officer that you violated your probation the way the affidavit report says you did.
Yes.
And you're waiving your right to a hearing where the state would have to prove that violation.
Yes.
You'll be adjudicated guilty, be placed on 3 years of probation in the new charge. And in the VOP, you'll be reinstated and modified your probation. Otherwise, the conditions will be the same, that you'll be sent to, you'll complete the Keaton program, including any aftercare. Cost supervision will be waived. You must get employment or try to get employment, and no substances without a prescription, and testing to confirm that. And the state's taking no action on the FTA, correct?
That's correct, yes, sir.
Is that what you understood you were doing? Have all your questions been answered about the plea?
Yes.
And how it affects you?
Yes.
And you satisfied with how you've been represented?
Yes.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Redstone.
And then Mr. McKinney, I show Randy Williams with you. Did we take care of?
We did. We set that over the next week with the denial.
Oh, that's right, okay. All right, so then we have our other pretrial detention, correct?
Correct. And he is present before the court.
Your Honor, DeAndre Seymour Short in 26 CF 692.
Your Honor, David Snell for the state in this case, and the state is, this time would be asking for a continuance until next Thursday. My law enforcement officer is not available to be here today.
All right.
Your Honor, I would just like to point out for the record that the first appearance judge in this case gave the state 72 hours to file the pretrial detention motion. As you can see, Mr. Seymour Short is here. He posted his bond. That was $5,000 cash professional in addition to $15,000 cash professional, in addition to another $5,000 and $3,000 cash for professional. And he did arrive to court early today and has been here, as well as is going to be very involved in his case. We would ask the court to maintain the same bond.
Well, I'm not going to take any action on the bond. He posted the bond, but the motion will be continued to give the state the opportunity to pursue the pretrial detention, which they have the right to do actually at any time during the pendency of the case. So it'll be reset for 4/23.
Understood. Thank you. 423.
Granted. All right, so is that squares away our pretrial detention? That also squares away the morning docket, correct?
That's correct.
All right, so we'll take we've got 15 minutes, so we'll take a 15-minute break, and then we'll be back at it at 1:30.
All rise, please.